Should you make a living trust? Today I'm going to give you the decision tree that will allow you to decide if you should make a living trust. Welcome to LifeCounsel podcast, your guide to understanding estate planning and elder law in plain language. I'm Jesse Bifulco, attorney and founder of LifeCounsel. In each episode, we break down complex topics into practical steps you can take to protect your assets, avoid family conflict, and prepare for life's unexpected turns. Because planning isn't just for the wealthy, it's for anyone who wants clarity, security, and peace of mind. Let's learn together. I'm part of a national group of estate planning lawyers. We meet online to talk about what works and what doesn't in different states. I've noticed that in some places, lawyers don't use living trusts that much. Some don't see the value in them that I do. Maybe it's because probate is easier in their state. Maybe it's cultural, or maybe they're still following that old will harvesting business model I talk about in my Lawyer's Edition podcast. Whatever their preference, I tend to favor using living trusts as the central estate planning document of an estate plan. That is, a living trust as the central document instead of the last will as the central document. But how to decide? In this episode, I'll show you how to decide and illustrate with real-life examples. I'll give you the reasons why you might want to use a living trust instead of a last will. By the way, living trusts are also called revocable trusts or revocable living trusts. Sure, I could rattle off a dry list of pros and cons of living trusts, but you likely wouldn't get any benefit out of that. Instead, I'm going to tell you stories that drive home the points. What is a living trust? Think of it like a container that holds your money, real estate, your jewelry. While you're alive and competent, you're the only one with the key to the container. But if you lose your mental capacity or die, the key automatically goes to someone you choose. This can be very useful, as we'll see in the stories that follow. A trust is about ownership of property, that is, money and real estate and personal assets, by an entity called a trust. Some states treat trusts like corporations, like entities. The more traditional trust definition is a relationship. That is, the trustee owns the property for the benefit of a beneficiary. With a living trust, they are both the same person. In other words, if you make a living trust, you manage the property for your own benefit, and you make the instructions about when someone else gets to hold or use the property. The trustee, that is the person who owns and manages the trust assets, is also the beneficiary. That is the person who uses and enjoys the trust assets. Sounds kind of stupid, really. Why have this fiction at all if the same person who has title to your money and property, called the trustee, and the same person who also gets to use and enjoy the money and the property, the beneficiary, that's you, right? If they're all the same person, why call it a trust at all? Isn't that the same as me owning and using my property? Well, the answer is no. It's not the same thing. The difference is that if your house and your money and investments are owned by your living trust instead of you, if you become mentally incompetent, your assets are owned by the trust. You can name someone in advance to manage your assets because the trust owns them. We're just swapping out the boss. We're swapping out the manager. Mental incompetence comes in a couple different flavors. One of my clients called it doolally, as in, if you've gone doolally, which is a particular kind of incompetence. The other flavor, if you're a Frank Capra fan like me, is called pixelated, and you could be both. The point is, if you're doolally or pixelated or both, you may still be signing legal documents. You might still be signing checks and deeds, maybe even a marriage license. In the context of estate planning and elder law, we're usually referring to loss of mental capacity as it relates to aging, like senile dementia or Alzheimer's. But it could also refer to a change in mental state where your surviving spouse becomes infatuated with a new partner and disinherits your children. Technically, if you become romantically infatuated with a new partner, that would not be doolally or pixelated. That's called Twitterpated. But anyway, seriously. The point is, if your trust owns your property and you lose your mental capacity, another trusted person, maybe it's your spouse or your child or your trusted advisor, that person can step in and protect and manage the trust property for you. A living trust can protect you during a time of vulnerability. Likewise, if you die with a living trust, you have already said who is going to manage your trust property after you die. Well, you say, isn't that the same as a last will? The answer there again is no, because a last will only takes effect after you die. In other words, if you have a last will as the central estate planning vehicle, and then you go doolally or get pixelated, or even Twitterpated, that is, you lose your mental capacity, the last will won't help you, because last wills only take effect after death. If you're alive but mentally incapacitated, a last will is useless. Once you die, the will is the thing to look at. But unlike a living trust, a will does not take effect immediately. It has to be probated, that is, proven in court before the last will can be any help. Now for the stories that drive the point home. The first story is called The Tug of War Over Mom's Checkbook. Since her husband Paul died, Judy had been living on her own. After the initial shock, she adjusted and began to build a new life and routine. Her husband's sudden death put Judy in mind of the fragility of life. So, she immediately patched things up with her estranged daughter. She flew out to Arizona and spent a month with her daughter, whose name is Wicked Witch. She and Wicked Witch posted images and videos of every moment of their reunion all over the Southwest. Her other daughter, whose name was Snow White, lived near her. In town, she saw her more often. Comfortable and close, they were beyond the video posting phase. Judy also picked up a regular beau. His name was Bob. It wasn't anything super passionate, but they both enjoyed the same activities, and it was great to have a pickleball companion. Then one day, Judy had a scare. After a pickleball match, she didn't feel quite right. Her mobile phone looked like hieroglyphics. Her arm felt weak. The left side of her face didn't respond when she smiled nervously at Bob when he asked her, "Are you all right?" When she said she was fine, Bob thought she'd had too many martinis because Judy's speech was a little woozy. Judy went straight to her doctor, Dr. Summers, who also happened to be her cardiologist, and he confirmed her suspicion. Judy had had a stroke. That night, she put 50 cents into the internet and out popped a last will and testament. She got her neighbors to be witnesses and signed the last will and figured she was all covered for estate planning. 2 years later, Judy lost her mental capacity. Snow White dropped everything and immediately went over to help her mother. She called her sister, Wicked Witch, to tell her the bad news. A week later, Snow White got served with legal papers. Her sister, the Wicked Witch, had petitioned the probate court to be Mom's guardian and conservator. Snow White didn't know what to do, so she hired a lawyer. She knew her mother would not want Wicked Witch to be her guardian. She said to her lawyer, "Mom made me the executor in her last will." The lawyer answered her, "A last will does not have any power over your mother or her estate while she's still living. Being her executor won't help." Then the judge sends out a guardian ad litem or a visitor, or whatever it's called in your state, to investigate, to find out about Judy's living conditions. They cite her boyfriend, Bob, because the probate code in their state says that unregistered domestic partners need to be brought into this mess. Then the guardian ad litem gives an opinion that Judy should have her own lawyer. They ask Dr. Summers for his medical opinion about Judy's capacity, but he says, "I'm a cardiologist. I don't know if Judy has the competence to sign legal documents. I can tell you about her blood pressure if you want." So, Wicked Witch hires a doctor to testify, and on the advice of counsel, so does Snow White and Judy's lawyer, who was appointed by the court. He also hires a doctor. The doctors read the records and examine Judy. The lawyers conduct depositions and exchange discovery. The Wicked Witch brings into court all the videos Judy made with her on their trip to Grand Canyon. That trip out to her house in Arizona. Wicked Witch conveniently leaves out the fact that it was Judy as the parent trying to bury the hatch with her problem child. She doesn't mention that it was the first time they'd set eyes on each other in 20 years, and that Wicked Witch hadn't even gone to her father's funeral. Snow White doesn't bring it up either because she doesn't want to hurt her sister's feelings or have that be the last thing they ever say to one another. But anywho, people don't come with labels, and the judge can't just jump to the conclusion that Wicked Witch is Wicked Witch and that Snow White is Snow White, because those aren't their real names. And do you think that whole guardianship proceeding sounds expensive? Well, it is. And guess who pays for it? Judy does. Now let me ask you folks listening, what could Judy have done to avoid all this? The answer? She could have said in advance what she wanted. Let's call that her instructions. And spoiler alert, those instructions are going to be in a living trust. She could have written it down in a legally enforceable document called a living trust. And what might those instructions have said? They might have said, if I lose my mental capacity, Snow White will decide how and where I live. My financial advisor, Sam, will decide how my money is invested. And I never want to live in a nursing home. Even if the trustee, Snow White, has to spend all my money to have aides come to the house and build an elevator in my house. The money I've saved up is for aging in place if I need it. And it will be a relief to Snow White knowing there are resources to take care of me and she doesn't have to reach into her own pocket. Or alternatively, Judy might have said, Snow White will be in charge, but I don't want my money being all spent up on the cost of my care. If it is legal to do so, I want as much of my estate preserved for my children and grandchildren. And if it's possible, and I need that level of care, I want my agent and a power of attorney to apply for Medicaid nursing home benefits. And in either case, Judy could have said that if Snow White cannot act as my trustee for any reason, then I name my best friend from college, June, or my financial advisor, Sam. In short, anyone but my daughter, Wicked Witch. So, in putting weights on a scale to decide if you should make a living trust or last will for your central estate planning tool, put on the side of living trust this weight, right? If we're going to weight it. It avoids guardianship and conservatorship proceedings. Living trusts help you avoid guardianship and conservatorship proceedings, or the necessity for one. It also ensures that your specific instructions are carried out. Now imagine Judy didn't have any children. Are specific instructions more or less important for someone who doesn't have children? For the answer to that question, if you're single, you should listen to my podcast, episode 9, entitled Estate Planning for Singles Without Children, 3 Pillars to Protect Your Future. That episode gives single planners a blueprint of what single person's estate plan instructions might look like. But getting back to trust instructions, why do I say it is a virtue of a living trust that it can contain specific instructions? Because when I teach my class on estate planning to the adult ed program in my town, almost every time I ask the class, what could Judy have done to avoid this? Someone will shout out, Judy could have made a power of attorney. Then I say, has anyone here seen a power of attorney? A power of attorney gives powers, but they're not all the same, and powers are not the same as instructions. A hammer is a tool, and a hammer has power. But without the blueprints to our cottage, the hammer might just be used to build an outhouse instead of a cottage. The power of attorney is like the hammer. We may need a power of attorney to build our living conditions if we lose our mental capacity, but we need the plan, the instructions, to know what we're building. Are we building an aging in place plan, or are we building an asset protection plan? Unlike a power of attorney, a living trust can contain those specific instructions. For instance, a power of attorney says, my agent has banking powers. A living trust says, I never want to live in a nursing home. A power of attorney says, my agent has real estate powers. A living trust says, keep my beach house in the family for generations to come. A power of attorney says, my agent has gifting powers. A living trust says, preserve assets for my kids if I go into a nursing home. You see the difference? Okay, so now for the next story. The next weight on the scale. When I take on a new client, before they become my client, they fill out a form. Most are fine with that, but occasionally they'll say, usually kind of apologetically, I didn't want to give you all that information until I met you first. I'm good with that because my form asks them for all their private financial information, what real estate they own, what bank accounts, but why do I ask them for the specific financial information in the first place? Because that's one of the factors that I use to determine if I think they should have a living trust or not. And in the process of making their plan, if they do make a living trust, in order for the living trust to operate as it is intended, that is, to avoid guardianship, to avoid probate, to have privacy, to have those things, the trust has to own your property. In other words, imagine you give instructions to hand your purse over to a trusted protector if you should ever pass out. Then you don't put your money in your purse. One day you pass out and they take your purse and they give it to your trusted protector, but your protector opens up the purse and there's no money in there to pay your bills. Or if you die, they have no money in there to give to your beneficiaries. So for a trust to work right, not only does it have to have your instructions, but you got to put your money in it. Your house, your money, your property. Because if you didn't put anything in your purse, your trustee is not going to be able to pay for those expenses that you need. So putting money in the purse is called funding the trust. We'll talk more about that later. The next story is about Bill and Regina. They'd lived and worked in Maine. When they retired, they decided to get a place in Arizona and see how the Snowbird thing would work out for them. Well, a couple years later, they decided Arizona wasn't for them. Then they decided to try Florida. They bought a condo in St. Pete. They ultimately decided that Maine was best for them, so they spent most of their time in Maine. But they rented their places in Arizona and Florida. They didn't want to sell because the real estate had appreciated in value and they enjoyed spending the occasional week or even a month in one or the other of those two houses. When Bill died, Regina traveled less, but she kept that rental income. Her grandchildren were all in Maine, and the kids needed her to get them from the school bus stop or to babysit to help out with the kids. She was a real asset to her daughter during that time. Regina made out her last will carefully. She left a share to her grandchildren, but most of it she left to her daughter. In the will, there was a trust so that her grandchildren couldn't buy motorcycles when they turned 18, and her daughter couldn't lose the inheritance if she ever got divorced. When Regina passed, guess what? Her daughter had to probate the last will. That means before her daughter could get access to Regina's money to pay the real estate taxes on her 3 properties and pay the homeowner's insurance on the 3 properties, she first had to be appointed by the probate court, but not just in Maine. Regina's daughter also had to be appointed in Florida and Arizona. 3 probates. It took months and cost thousands and thousands of dollars. During all that time, it took to get appointed the executor of Regina's estate in Maine and Arizona and Florida. The market dropped and the estate lost money, and the homeowner's insurance lapsed on one of the houses. The condo association in Florida penalized the estate over some unpaid special assessment. The 3 different law firms that Regina's daughter hired did not communicate with each other. Ugh. To recap our audit checks, audit check number 1 was, should I have specific instructions? The audit check to see if you should make a living trust, right? So number 1 was, should I have specific instructions that cover me not just after my death, but during my life if I lose my mental capacity during a period of vulnerability? If the answer is yes, that's a weight on the scale of making a living trust. Audit check number 2, do you own real estate in more than one state? If you do, that's another weight on the scale in favor of making a living trust as your central estate planning vehicle. To put it more generally, are there reasons that probate would be more expensive for you? The reasons that probate can be more of a problem span the spectrum from probate is always expensive and time-consuming in my state. And if you want to hear a great story about that, listen to episode 2, The Laughing Heir. Probate can be a nightmare, to see what probate can look like. Anyway, the reasons that probate can be more expensive span a spectrum, right? From probate is simply more expensive in my state to reasons like I have real estate in multiple states. Also, a delay in administering your estate can be very detrimental. Think about it. If you own a going concern, a business that you manage, that's a chief source of a profit to your family, income to your wife or your husband. That's a big asset. If you suddenly die, probate could really screw that up. So all these factors would be weights on the side of making a living trust instead of a last will as your central estate planning vehicle. Now, let's talk about looting an estate and remarriage protection. That sounds awful, doesn't it? When I hear the word looting, it conjures up something out of the Game of Thrones or medieval drama. The enemy army is at the gate of the town. They want the spoils, the loot, but the town has a wall around it. So the army first has to break down the gate to get the loot. Once they break down the gate and flood into the town, they loot the belongings of the townspeople. Okay, so that's where the word looting comes from. What is looting in the context of estate planning? That's our next story. John had been married 4 times. He had 2 children with his first wife. They were named John Jr. and Rebecca. His first wife died young, and it was tragic. He had a great relationship with his kids, but he was a man, and he was independent, and the kids lived far away. And after John's 3rd marriage and subsequent divorce, he moved again, this time to Key West. In Key West, he met Anne. Anne was about 8 years younger, but not a kid. She was a grandmother like John and had a daughter who was divorced and struggling to raise Anne's 2 grandchildren on her own. John said to Anne, and Anne said to John, "You've got kids. I've got my kids. You've got your own money. I've got my own money. We have a great time together, but we're not getting married." John told his children at dinner and told Anne and told anyone who would listen, "I am never getting married again." And the kids didn't worry because they thought Anne was good for their father. After a couple of years, John and Anne decided to buy a house together. It was cheaper than living separately. Again, Anne's net worth was well over $1 million, and she didn't want any of John's money. She had her own business, too, selling souvenirs to Canadian tourists. Her store was even on the internet. Anne liked her independence and hadn't had a good marriage herself. But one day, a few years later, John Jr. got a call from Anne. She and John's father, John Sr., were getting married. John Jr. was perplexed. Married? After those first 2 disasters, after Mom's death, Dad swore he'd never get married. Even Anne said she'd never get married. But lo and behold, the wedding was all set. John Jr. called his sister Rebecca. Rebecca wasn't surprised. The last visit she made down to Key West, Anne's daughter was complaining the whole time about how she needed money, and Dad was not himself. He just nodded and agreed with anything and everything that was said. He wasn't the U.S. Marine Corps veteran who they knew and loved anymore. John was a shell of his former self. Rebecca and John Jr.'s father had advanced senile dementia. It came on quick. So now, when he was fragile and compromised, and so many miles away from his son and daughter, the sieging army broke down the gate. Suddenly, John wanted to get married. You all listening know what's coming next. Rebecca and John Jr. find out that their father has changed his last will after he dies, naming his new wife Anne as his beneficiary. And Anne's beneficiary is her daughter. And one day, Rebecca and John Jr., they see their mother's tea set and the sapphire ring their father gave their mother for sale in the online store of Anne's gift shop. The rest of the estate all goes to Anne's daughter after Anne dies. Not a good result, right? Going back to our siege of the city analogy, John's mental capacity was the gate to the town. He loved his children, and they were the product of his first love, his wife, who died young. But life is long, and he, like anyone else, needed a companion. He'd found 2 others in his younger years who didn't work out. He learned his lesson. You can have a companion without getting married. He'd put up that gate, but the gate was broken down once he lost his mental capacity. Living trusts can also be a protection against that scenario. John was his own gatekeeper, but he fell asleep on the watch. With a living trust, he could have had his children be his backup gatekeepers, what are called successor trustees, or maybe even co-trustees. That way, if he fell asleep, they could automatically be the gatekeepers and stop the looting. So to recap, audit check number 1 was, should I have specific instructions that cover me not just after my death, but during my life if I lose my mental capacity? If the answer is yes, that's a weight on the scale of making a living trust. Audit check number 2. Are there good reasons to avoid probate? Would probate add to the expense or cause loss to my estate? That's a weight on the side of making a living trust. And now audit check number 3. A second marriage or informal marriage-like relationship between 2 people who have different children or different remainder beneficiaries. That's another weight on the scale of making a living trust instead of a will as your central estate planning vehicle. In that scenario, you might want to benefit your partner, but you don't want them looting your estate if you're alive but lose your mental capacity or even after you die. And that can be done with a solid living trust-based estate plan. Now for the public proceeding concern. Again, this isn't a concern in every person's estate, but it is in many. Have you ever gotten a call or an advertisement that, and then said to yourself, that's weird. I was just talking about that. We were just talking about going out to dinner, and then mysteriously on my feed, all these ads for a local restaurant show up. How about a phishing phone call or email or direct message that sounds legit but isn't? The reason the scammer sounds legit is because the communication contains unique personal details. You read it or hear the person on the other end and say, oh yeah, that's my bank. Or yes, I know that person. Or that's the model and make of my car. Or I have an account there. When you hear those little details and they're accurate, they add up to trust in someone you shouldn't. They convince you or almost convince you to give the scammer more personal information that they didn't know already. And you almost fall for it, but you catch yourself before it's too late because you're not in a compromised state. That is, you consider yourself to be fully competent. You're not pixelated. Which, if you ask your husband or your wife, am I competent? They may disagree, but that's a different issue. Anyway, now let's imagine there are states of mind or situations where you aren't operating at full capacity, and that's when a scammer strikes. Isn't it more likely they'll succeed in scamming you if you're in that vulnerable condition? What do I mean by that? Let's revisit the first story we told, the tug of war over mom's checkbook. In that story, mom's daughter, the Wicked Witch, commenced a guardianship proceeding. Well, a court proceeding is a public proceeding. Even a probate proceeding is a public proceeding. And in both of those public proceedings, the people involved are compromised. They're not operating at their highest capacity. So when you or our family are going through emotional turmoil, like the mental incapacity or death of a spouse or parent, the whole world gets to know about it. Phishing scammers find out about you in many ways, but one of the most effective ways they find out is through public records. And court records are public records. But most people I've asked don't want the whole world to get notified if they've lost their mental capacity or even if they've died. They want more control over their personal information. Imagine when you die, your nearest relative who you actually disinherited gets a letter asking if they want to contest your will. Or scammers find out your family is in mourning and fumbling with a probate, and the scammers send them a realistic-looking bill for services. And they can't verify if that's an accurate bill because they can't ask you because you're dead, right? That leads me to my next story. Sarah and Jeff bought an old VW bus right after high school. Neither of them had great relationships with their family. Sarah's brother Cal could charm the paint off the wall. He was the favorite, and somehow her parents never saw through his act. But Sarah did. She'd had enough of living in Cal's shadow and being played by her manipulative, evil brother. Somewhere in Arizona, Sarah and Jeff started roasting coffee over a campfire. What began as a cozy morning ritual in the desert grew into the $1 million company Barefoot Roasters. Coffee with dirt under its fingernails. They believed coffee should taste like where it came from, honest, earthy, and real. Then came the venture capital. 30 years later, they've just sold the company, a brand built from a bus, and they're retiring now with millions. As they sit down to make their estate plan, the old VW still waits in their garage, rusted, sun-faded, and full of memories from when it was just the two of them, a campfire and the smell of coffee in the desert air. And here's the catch. Sarah and Jeff never married. They don't have kids. So if something happens to Sarah, her legal heir isn't Jeff, it's Cal, the brother she deliberately won't let know where she lives or give her phone number to. That's her legal heir. Jeff and Sarah don't want to get married, but they definitely don't want Cal getting a probate notice. So let's put one more weight on the scale in favor of making a living trust. Audit check number 4. If you do want your estate to stay private and in the right hands, then you probably want a living trust. Sarah and Jeff's story reminds us that even if you make a will, it still goes through probate, and probate is a public process. That means the court sends official notices to your next of kin, even the ones you'd rather forget. And anyone can see the details of your estate simply by clicking a button and looking at your will online. I call probate notices an engraved invitation to contest the will, because somebody who's written out of the will gets a notice that says, hey, your sister died, you're her heir, but she didn't leave you anything. Come to court on Wednesday if you want to contest the will or forever hold your peace, right? So what is that person tempted to do? They're tempted to go and contest the will. So probate notice, an engraved invitation to contest the will. And it's not just family who gets those invitations. Once a probate or guardianship hits the public record, it attracts opportunists, scammers, data harvesters, long-lost relatives, and anyone who makes a living preying on the grieving or the vulnerable. A living trust keeps all of that off the public record. No court notices, no open files, no engraved invitations. It's not just about avoiding probate, it's about privacy, protection, and control. That's the lesson from Sarah and Jeff. If you don't choose your plan, the law and the public will choose it for you. So, should you make a living trust? Let's recap what we've learned. A living trust isn't about how much money you have, it's about how much control you want. You should consider making a living trust if, 1, you want to stay in control even if you lose mental capacity. A trust gives clear instructions, not just powers. It tells your chosen person exactly how to manage your affairs if you become ill or pixelated, as we said earlier. A will doesn't help you while you're alive, only a trust would. 2, you want to avoid guardianship or conservatorship court. With a trust, no one has to go to court to take care of you or your property. The people you name can step in automatically. 3, you want to avoid probate and save time and money. A will has to be probated before it works. A trust works immediately. That means your family doesn't wait months or pay lawyers in multiple states just to get access to what's already theirs. 4, you own real estate in more than one state. Each state means another probate. A single trust can cover them all. 5, you're in a second marriage or a relationship outside marriage. A trust protects your partner while keeping your children or your intended heirs safe from being disinherited. It protects your assets from being looted. 6, you value privacy and want to keep your affairs out of public records. A will is public. It sends an official notice to your relatives, even the ones you'd rather not hear from, what I call the engraved invitation to contest the will. A living trust is private. No court notice, no file, no audience. So if you want your plan to protect you while you're alive, stay private when you pass, and make things easier for the people you trust, that's when you should consider making a living trust. Thanks for listening to the LifeCounsel Lifecast, where real stories become real lessons about protecting family, legacy, and love. If today's story got you thinking, share it with someone who needs to hear it, or start your own conversation with a qualified estate planning attorney. To learn how to choose an estate planning attorney, listen to episode 8, 5 Insider Tips to Choose the Right Estate Planning Attorney. And remember, a will or trust or a power of attorney, they're just tools. And the life you want isn't about collecting tools. It's using the right tools to build your individual plan. It's about writing your own instructions before someone else writes it for you. I'm Jesse Bifulco, and this is the LifeCounsel Lifecast. See you next time.